Thank you for joining us for the Beverly Hills Bar Association's Legal Issues in the Age of COVID-19 webinar on labor and employment and insurance law. My name is Michael Sohigian. I am the current president of the Beverly Hills Bar Association, and I will be moderating this discussion between two very experienced, knowledgeable, and competent experts in their respective fields. You have Steve Raucher, who is a partner in Reuben, Raucher, and Blum. He has a business litigation practice with a focus on insurance coverage, representing businesses and individuals to get coverage in various situations. And Daphne Bishop, she is a partner at the Carothers firm. She represents employers in labor and employment matters, both litigation and counseling. Thank both of you for being here. Steve and Daphne have bios in your materials. This is good for 1 hour of MCLE credit. You will be receiving a certificate of attendance by email tomorrow. We have a lot of people on the line. We're using Zoom. We now have 156 participants according to our numbers. We have both a chat function and a Q&A. So if you have questions, click on the Q&A icon at the bottom of your screen, and you can type a question, or you can also use the chat function. And I will be keeping track of the questions if there are any comments and the like, and I will pass them to Steve and Daphne when there is an opportunity to do so. So I wanted, before we get into the meat of the matter, I want to remind folks that the Beverly Hills Bar Association has 510 MCLE courses, all of them online, in 24 different practice areas, and we have a special offer, unlimited access to our CLE library. If you are a member of the Bar Association, it's $75. If you are not a member, it is only $100. And like I say, that's unlimited, all 510 courses, and it includes ethics, bias, and competence issues. Okay, so with that out of the way, let's go to our program. First, Daphne Bishop, as I say, a partner at Carothers, DiSante, and is that Freudenberger or Freudenberger, Daphne?
Freudenberger.
Okay, all right. I'm going to stop talking. I'm going to let you do it. Okay, take it from here, please.
Thank you, Michael, and thank you, the Beverly Hills Bar Association, for having me today. I hope everybody out there is healthy and well and surviving during these difficult times. I've got about half an hour here to talk about employment issues that have arisen in light of the COVID-19 crisis. And I could probably talk for hours about all that's been going on, but decided that what might be most helpful to your members is to kind of just give an overview of the major federal, state, laws and rules and orders that have had an impact on employers and employees since this outbreak started. And also with the caveat that things have been changing day by day. All of these new laws come with a plethora of new regulations and guidance. And so every day we're sorting through and trying to figure this out. And so I'll do my best to give you the good information that I have today, but I might not know all the answers to your questions off the top of my head. At the end of this, and my email's also in the materials, so if you have questions, please feel free to reach out to me. All right, Oh, and also another caveat that I wanted to put out there is that what I'm talking about today is applying to general employers. If you are a healthcare employer, or if you employ emergency responders, some different rules apply to you. Also, if you have employee force that's represented by a union, you might have some different rules that apply to you also. All right. So first, I'm going to go ahead and dig into the first. Well, actually, this is part two. This is the second law that Congress enacted in response to the coronavirus, the Families First Coronavirus Response Act. And there are two parts of this law that that have a major impact on employers. And so I'm going to go through those two parts. So first is this emergency paid leave provision, or this new emergency paid law, really. It applies to employers that have 500 or fewer employees. So this is for medium-sized and small employers. There's an exemption for employees of 50 or more, but you have to prove certain things, which I'll go through in a moment. But this emergency paid leave law basically says that employers with 500 or fewer employees between the dates of April 1st and December 31st of this year have to provide paid leave to employees under certain circumstances. And so they're listed here, the 6 circumstances. The first is if the employee is subject to a federal, state, or local quarantine or isolation order related to coronavirus. And there have been some questions about that first one. What is a state, local quarantine or isolation order? The DOL, the Department of Labor, has been releasing a lot of guidance on interpreting these laws. And I think, it's safe to say that here in California, we've been under an isolation order for, I don't remember how long now. I'm losing track of the days. But in any event, I think it's safe to say that most of us now are under a qualifying isolation order. The second circumstances is if the employee has been advised by a healthcare provider to self-quarantine due to coronavirus concerns. 3 is if an employee is experiencing symptoms of coronavirus and trying to get a diagnosis. 4 is if the employee is caring for an employee who's under quarantine or under an isolation order or has been advised to self-quarantine. 5 is, this is another one that really affects a lot of people. If an employee is caring for a child whose school or child care has closed due to coronavirus. And then lastly, if the employee is experiencing a substantially similar condition specified by the Secretary of Health and Human Services. So that last one's just kind of a catch-all. So those are the circumstances when employees might be entitled to emergency paid leave. They're only entitled to get one leave during this time frame. So you can't have an employee say, okay, I want emergency paid leave because I'm subject to an isolation order, and now I want one because my child is out of school.
Daphne, we have a question from one of our attendees regarding the applicability of these provisions to public employers. So for example, somebody who works for a state agency, are they covered as well, or is this only private employers?
I know that private employers are covered. I remember seeing that federal employers are exempt, but I'm not sure about state and other local agencies. That's one. I can start a running list of questions, but I'll add that one.
Okay, thank you. It's in the Q&A, so we can. There's a record being made of it. And by the way, everybody, this webinar is being recorded, of course. So all of this will be available after the webinar is done, as soon as we can post it on Facebook Live, the Beverly Hills Bar Association YouTube channel, and our website. So thanks. Sorry to interrupt, Daphne. Go ahead.
No problem. Can we advance to the next slide, please? And so how much emergency paid leave are employees entitled to? It's up to 80 hours of paid leave. And there is guidance on the DOL website about how to calculate how much paid leave the employees are entitled to, because it's prorated for part-time employees. And it's not, just their regular rate of pay. There are some limits on this. And it depends on the reasons why the employers or the employee is taking leave. So if it's one of the first three reasons on the last slide, because the employee themselves are subject to a quarantine or isolation order, or because they're having coronavirus symptoms, then they're entitled to paid leave calculated at their regular rate of pay, but it's capped at $511 a day, or $5,100 in the aggregate for that whole period. For the other reasons on the list, such as childcare due to coronavirus, the employee is not entitled to as much money. They're entitled to 2/3 of their regular rate of pay, and up to $2,000 in aggregate per employee. As part of this, employees may not be required to use accrued vacation or pay PTO or other sick leave that they might have before they're entitled to use this emergency paid leave. So that means that, if you have vacation and PTO, you can keep that on the books. You can't force employees to use it, although some may choose to use it. I should mention that one thing that Congress did to make this a bit less burdensome for employers is to offer payroll tax credits for this. And so employers will be able to get payroll tax credits in the amount of the dollar for dollar for the leave that they give under this aspect of the law. I said I was going to talk a bit about exemptions. We've learned a little bit more about what they mean or how they're going to interpret this exemption for 50 employees or fewer. And the Department of Labor has set forth 3 different conditions. One is if you can show that providing leave would result in financial obligations that will exceed the available business revenue. The second circumstance is if you can show that the absence of this employee or these employees would pose a significant risk to the company's financial health or operational capabilities because of the employee's particular skills. Or lastly, if the employer can show that they're just not going to have sufficient employees available to operate the business at a minimal capacity. It's not exactly clear how employers get this exemption, if this is something that they apply for or just assume that you have and then deal with it later. We're kind of in the wild, wild west. So that's still up in the air, but it is out there. And if you have questions, I would certainly advise to check out the Department of Labor guidance. All right, can you advance the slide, please? Oh, no, actually go back one. Okay, that's it, sorry. So this is the second part of the Families First Coronavirus Response Act that has implications for employers, and this one is major. This one expands FMLA. So the FMLA has been expanded just for COVID-19. And so this is just for now, for April 1st, 2020 through December 31st of this year. It applies again to employers with 500 or fewer employees. There are also exemptions for smaller employees, as I just discussed. This FMLA expansion is broader than the regular FMLA, because under typical FMLA, in order to qualify to get FMLA, an employee has to have worked for 12 months and 1,250 hours But that's not the case here. The case here is that if an employee has been employed for at least 30 days, then that means that they're eligible. And that doesn't mean that they have to actually have worked for 30 days. They just have to have been on your payroll for at least 30 days. What is this leave allowed for? This is for employees who are unable to work or telework because they have to care for their child who is under 18 years of old because their school or daycare has closed or the child care provider is unavailable due to COVID-19. Um, again, this applies to a lot of people nowadays, and so this is a really broad bit of protection that has been enacted here. So how much leave is available? Just like FMLA, it's 12 weeks of leave. And this is not on top of the 12 weeks of FMLA that your employees might get because they had a baby or because they, had an accident or have to go on military leave or that type of thing. And the other big difference between this family medical leave expansion under the Families First Coronavirus Act and your regular FMLA is that this is paid. So weeks 1 through 2 are unpaid. During those 2 weeks, employees may choose to use their emergency paid leave, which I discussed a couple of slides back. Remember, that was up to 80 hours. And so the idea is that employees will use that leave during the first 2 weeks of this FMLA leave. And then for the remainder of the leave, weeks 3 through 12, they're going to be paid at 2/3 their regular rate of pay. And it's capped at $200 a day or $10,000 in the aggregate. So this is the intention is to keep employees who are unable to continue to work because their kids are home. The intention is to keep them going, but it's not going to make them whole at the 2/3 rate of pay. Another note that I wanted to make was that I said that this 12 hours is not on top of the other 12 hours that they may be entitled to. But I do want to caution about the California Family Rights Act, which is a state law that employees might get an extra 12 weeks on if they qualify under that. So that's just a little bit of a complication, California complication. And so I want to touch on the things that have been going on in California with respect to paid leaves. In 2014, it became law in California that employers had to provide paid sick leave to employees, and this is accrued paid leave, or you can choose to, or employers could choose to provide it upfront in a lump sum. But this is paid sick leave. And Governor Newsom signed an order that said that employees have to be allowed to use however much accrued paid sick leave they have on the books for any kinds of coronavirus related absences. So this is in addition to the other leaves that we've already talked about. And then the other type of paid leave is vacation or PTO. And this is really this goes by company policy. If this is something that you have and employees have accrued vacation or PTO, that's considered a wage that they've earned. And so they have to be able to use it. They can't be forced to use it, but they have to be allowed to use it. So that's another way that employees may seek to earn their wages during this time if they're unable to work. And there are also in California other ways for employees to get paid while they're on leave. They might be eligible for state disability insurance if they're sick with COVID-19 symptoms. They might also be eligible for paid family leave to care for children who or other qualifying family members. There's also unemployment insurance. Governor Newsom signed an order saying that everybody who has lost their job due to COVID-19, who's eligible to apply, does not have to wait the 1 week waiting period that they used to have to wait for that. So that's been waived for now. And then also I want to flag that workers' compensation leave might also come up because, I don't know how much of this employers are seeing at this point, but this is something that we might be seeing as certain businesses stay open, because employees might be getting sick with coronavirus in the course of working. And so if that's the case, then if they're public facing employees, then they would I would advise that they should make a workers' comp claim, and they may be entitled to benefits and protected leave in that case.
Daphne, we've had a couple of questions about calculating wages that were due. If an employee has their hours or rate reduced, or maybe has gotten a raise during the period preceding the furlough, how do you figure that out?
Is the question about how to calculate leave based on the rates, or are they I guess I'm not clear about the question. If they're asking about
They're asking, well, here's a question that says, if an employee has been put on part-time status and or had wages reduced, how do you determine how much to pay them, and how do you determine how to calculate the 80 hours? If an employee was reduced from 40 hours per week to 30 hours per week, and from $25 per hour to $15 per hour, how would you calculate their leave? And I think what
that
he
you
means
need
is
to,
paid leave.
for that, I would say go on the Department of Labor's website, because there's guidance on there about how to prorate.
And what is the lowest number of employees an employer can have and still be subject to these federal rules? Is it 50 or 49 or fewer?
It's one.
Okay.
It's employees of 500 and fewer.
Okay. All right. Not like 5 or more, the way that the fee
No.
high is. Okay. All right. Go ahead. Thanks.
Okay. Can we advance the slide? All right. So I wanted to talk next about the third piece of legislation that the federal government passed in light of the coronavirus crisis. And this one is the Coronavirus Aid, Relief, and Economic Security Act, otherwise known as the CARES Act. And there are three parts of this law that I wanted to talk about. First one is the Economic Injury Disaster Loan Emergency Advance. This component here is this is the latest component, and it all works through the Small Business Administration. And so there are these emergency loans that businesses can apply for through the SBA. And what Congress has done here is they've expanded these loans. And so they've expanded who can apply for these loans. And so now this is not only for businesses that qualify as small business concerns under the SBA, it's for businesses, cooperatives, stock ownership plans, small tribal business concerns with 500 or fewer employees. And it also applies to sole proprietors and independent contractors with or without employees. So basically, I mean, this covers a lot of private employers with 500 or fewer employees, and even companies or independent contractors that don't have employees. And so the loan that they're able to apply for here, the purposes are for paid sick leave, for paying out paid sick leave, for payroll, for rent and mortgage, and repaying obligations that cannot be met due to revenue loss. So, the idea is that this is $10,000 quickly to businesses that will help them right away stay in business. Congress allotted $10 million for these loans, and businesses that apply are eligible to get up to $10,000 per business. And they're not going to be and there's no requirement to repay the $10,000, even if the loan is later on denied. The loan the loan process seems like, the law says that all they have to do is a self-certification under penalty of perjury, and that advance is supposed to be paid within 3 days. I've been hearing that it's been very difficult to get on the SBA website and to process these loans, but I would just advise to keep trying.
And Daphne,
Mm-hmm.
there are some questions about the application process itself. The loans are made through private lenders, and they need to
Yes.
be SBA approved lenders. And I know
Yes.
from experience that some lenders have been having real problems with that. So there's a list of approved lenders on the website, but not all the approved lenders are actually making loans, at least not at this point. They're still trying to work through the details of that. So maybe it's just worth noting that here.
Yes, and I would also say to keep an eye on the SBA's website as well, because they're supposed to be releasing some guidelines also about how this program or these programs are going to work.
Yeah. And also, Brenda Magid has asked, we have undocumented sole proprietor, can they apply? By that, when somebody says undocumented, I presume that means that their immigration status is not documented. Do you know anything about restrictions about that?
I don't know anything about restrictions, but I won't be surprised if there are restrictions, because this morning I was learning that certain businesses, like the adult entertainment industry business, is not going to be receiving loans, but
gambling
I don't know.
too. Gaming also is excluded. There's a certain percentage. You have to get less than a third of your income from either adult and gaming.
Yeah, but I have not heard about undocumented sole proprietors.
Yeah, sole proprietors can get benefits under these SBA emergency disaster
That's
loans.
right, but I'm thinking you're probably going to have to show that you filed taxes. There's probably going to have to be something that you show that, but I don't know yet.
Yeah, that's not a question we're really capable of answering right now, Brenda. I'm sorry.
Okay, so to carry on, the second bit of the CARES Act that I want to touch on was the Paycheck Protection Program. So this is kind of another way of funneling money to employers so that they can keep people employed. Again, who can apply for this? Businesses with 500 or fewer employees. Also independent contractors and self-employed individuals who can apply for these. And so the period for this, there's a shorter time period for these. It's February 15th to June 30th. These loans can be used to cover payroll costs for continuing healthcare coverage, mortgage, interest, rent, utilities, and interest on any other debt obligations that were incurred before the covered period. And these loans are going to be allowed up to 10 million per business. And there will be loan forgiveness available if employers show that they kept employees on through June through June 30th, 2020, because this is the whole purpose of the loan, is to keep people employed, to keep people on the payroll. All right, and then let me go to the next slide, please. This is the third component of the CARES Act that I wanted to touch on, because it relates to employment, and this has to do with unemployment compensation. The federal government has increased unemployment compensation for a time period due to coronavirus, and there's a list of qualifying factors. The employee has to have been either diagnosed or have somebody in their household diagnosed, or they're caring for somebody who was diagnosed, or they're caring for their child whose school was closed, or they can't work because of quarantine or self-quarantine, like if they're this, if they where they work is closed because of this, if they became the head of household because of a COVID-19 death, or if the employee just had to quit their job due to COVID-19. So what are they entitled to here? Whatever they get under state law, plus an extra $600 on top of that. And it's for up to 39 weeks. And so this it does end up shaking out to allowing some low wage earners to get paid a little bit more than their regular rate of pay. But Congress decided that it was just easier to just do 600 per person. That would be easier and a bit of more of an average. All right, can we go to the next slide? I wanted to touch lastly on layoffs, furloughs, terminations. First, I wanted to say, be sure to review all local orders if you have a business that is still open, because all of these orders are, they're slightly different. They have different requirements. They define essential, who's essential in different ways. And so in making decisions about who can and can't continue to work, I would say you should look at all the local orders. Another thing that I would say you should look at are the Federal WARN Act and the California WARN Act. These are laws that govern mass layoffs and terminations, and usually require a certain amount of notice before an employer can do a mass layoff. The Federal WARN Act has a clause of, that says that it may be exempt in cases of emergencies. I forget all the language, but there is a clause that seems like it applies here to this economic disaster. But the California WARN Act doesn't have a similar provision, but Governor Newsom did hand down he signed an executive order that loosened the notice requirements. It didn't do away with them, it just loosened them. So if you think that Cal WARN applies, I think that I would suggest taking a closer look at that, retaining an attorney to make sure that the notice has all of the bells and whistles that it's supposed to have. Otherwise, employers will be subject to penalties, and including some back pay. And then also, if you're considering layoffs and selecting employees, I would say take a look at a disparate impact. Make sure that you're not only impacting certain groups of employees, because you can. I would expect to see a lot of litigation once this is over, and people can't get their jobs back, and people are looking for ways to make a living. Another thing is when employees are let go, their final wages need to be paid immediately. I've been advising clients that does include any accrued unpaid vacation and PTO. There's some question about whether it's a furlough or a layoff. Do I still have to pay that out? The labor commissioner has taken the position that you do. And if you get hit with a DLSC complaint and appear before the labor commissioner, you probably have to pay penalties as well. I think the safe thing to do is to just go ahead and pay it if you're able. But I know there's some debate about that. And then lastly, like with all terminations and even layoffs and furloughs, there's an unemployment pamphlet and a California form that has to be provided to employers. So I went a bit over my time. The last slide here just has a list of links to resources that you can look to. The last one is a shameless plug to my own firm's COVID-19 Resource Center, which is very good. And I'm not just saying that because I'm one of the people who's provided some of the content.
Well, there have been a lot of questions, as you might imagine, Daphne, and we will review the questions on the Q&A there and try and get some responses, either with the time that we may have left today, which probably won't be very much, or thereafter. We have information about the people who have asked the questions, and Let's go to you, Steve, and let us know what kind of insurance coverage issues might be available for businesses that have had their operations suspended or impacted by the COVID-19 crisis, please.
Absolutely. Thanks, Mike. And good afternoon, everyone. Maybe you can go ahead and go to the next slide. I realize that the participants in this program probably have varying levels of experience with insurance. So apologies if some of these concepts are very basic, but I want to make sure that there's something here for everyone. As a baseline matter, we have really two potential types of insurance that can be impacted here. One is first-party insurance coverage, and the second is third-party insurance coverage. First-party insurance coverage means that the policyholder itself has suffered some kind of damage and is seeking coverage for it. Third-party insurance coverage provides the policyholder with a defense and potential indemnification when someone else, a third party who has sued the policyholder, has been damaged. And both types of insurance are potentially implicated, but I'm going to focus my discussion today on the first party claims. I think that's what most people and most people's clients are going to be most interested in at this point. I suspect then in about 6 months, we're probably going to have to do another program that focuses more on third party claims once we've gotten past the crisis and hopefully business has begun to return to normal. The primary coverage in first party coverage that you'll typically find in a property insurance provision is called business interruption coverage, and it actually is composed of several different things. The prior slide I just put on there because it was a press release from the insurance commissioner of the state of California, in which he put out a memo that said that he's going to be collecting information about business insurance coverage and business insurance claims from insurance companies in the state of California. And what it is a recognition that there are going to be obstacles and issues in many cases for policyholders getting this kind of coverage. And so the insurance commissioner is paying attention. Lawmakers may ultimately pay attention. And there may be encouragement of carriers to provide coverage when they otherwise might not want to, or there may be legislative fixes. We don't know, but I think that order, the details of which are not as important, is sort of symbolic or emblematic of what's going on with the state looking over the shoulder of the insurance companies. Now, the first type of insurance coverage, and the one that most commonly people think about, is lost business income. So the policyholder itself has lost business income because they've had to suspend or reduce their operations in some way. And so you might think to yourself, well, what's the catch? This seems fairly straightforward. My business is off because of the coronavirus pandemic. Well, the catch is that as you look in the highlighted portion there, the suspension of the operations must be caused by a direct physical loss of or damage to property at the described premises. Described premises will typically be the policyholder's place of doing business, or plant, or factory, or what have you. And the loss or damage must be caused by or result from a covered cause of loss. So you've got two immediate obstacles before you even get into arguments about how much. You have the obstacles of, was there a covered cause of loss, and did it involve direct physical loss? Then those are the two things that I'm going to focus on today. If you're interested in some of the other issues that come up in terms of business income claims, I did put a link to an article that I wrote in the wake of the fires a couple years ago that goes through some of those. But there's a series of somewhat different issues that come up with the pandemic. So the next slide talks about covered causes of loss. And I would say the majority, most property insurance policies are what are called all risk policies, meaning that they cover any loss arising from any fortuitous cause, except those that are specifically excluded. Now, of course, exclusions can cover a lot of territory, and we'll get to those in a few minutes. But if you have an all risk policy, or your client has one, then at least you are now potentially in the game for having a business interruption claim. If you have a named peril policy, those apply only to specified losses. And I think you are in that case gonna have an uphill battle unless pandemics are a named peril, which I don't think happens very often, then you're probably not gonna have a claim. But then let's assume that you have a covered cause of loss. Then you go to the next issue, which is property damage. And so what do I mean here? Deanna, can you go to the next slide, please? Thank you. So as an example, you have maybe a nursing home that's been actually shut down by the authorities because there was a contamination within that actual premises. Or it could be a factory that was shut down because of contamination within those specific premises. Does that contamination by the virus constitute a direct physical loss? The good news and the bad news is that there's not any direct authority under California law. So, and maybe there will be by the time this is all over, but for now, we can only turn to what other jurisdictions have found. And there is some fairly recent case law. This case, Gregory packaging case, will be in your materials, as will the other two cases. But the Gregory packaging case involved a situation where ammonia was released from a refrigeration system into a facility. And the policyholder made a business interruption claim, which was denied. And the district court found that ammonia contamination or smell that was in the building did constitute a direct physical loss, and that it was not necessary for a property to sustain physical loss or damage without experiencing structural alteration in order for there to be a direct physical loss. So that's a pretty good analog to the pandemic, I think. The next case, Mellon versus Northern Security Insurance from the Supreme Court of New Hampshire, cited Gregory packaging and a number of other cases going in both directions. That case involved a property owner who had a problem with a neighbor that had apparently an excessive number of cats, and the odor from the cat urine made the property that was insured uninhabitable. And also, when they went to sell the property, they had to sell it at a significant loss. In that case, too, the court found that direct physical loss can encompass changes perceived by the sense of smell, which renders the property unusable. So again, there was no need for actual physical loss or structural loss to the property. It didn't have to be something like a fire. Now, there's case law going the other way too. This Universal Image Production versus Chubb case out of Michigan, applying Michigan law, found the situation there was a water leak which caused mold, odor, and bacterial contamination. And you actually had employees who were going into the structure who needed to be wearing respirators, and you had one of them come down with bacterial pneumonia. But the court in that case found that because there was no actual structural damage to the property, that did not constitute a physical loss. So if one wants to be optimistic and assume that under California law, which is relatively policyholder friendly, one might say that there's a good shot at being able to argue that if your facility, your client's facility, had to be shut down because of direct contamination, that there was a physical loss. But of course, most of the claims are not going to be because of being shut down, because of the shutdown orders from the state or from the city. And there is potential coverage for that, which we'll get to in a second. I just want to briefly mention another subset of business interruption claim, which is extra expense coverage. If you otherwise meet the definition for lost business income, you oftentimes also have this extra expense coverage, which will cover the expenses necessary to avoid or minimize suspension of business, and continuing operations, including costs associated with setting up replacement premises or temporary locations, including relocation expenses. So, we all, many of us at least, have probably, had to have hastily set up or at least upgraded home offices. So this could cover things like, well, what if I had to buy a new computer, or I had to buy a new camera that I'm looking into right now, so to allow me to participate in Zoom meetings, things like that. That would be in the case of a law office, but other businesses probably have even more significant extra expense claims, assuming they can continue operations from other places. Now, the next slide is probably the most important, and it's what I referenced earlier. It's called civil authority coverage, something that frankly I don't think has been much litigated or much considered, but is now going to get a lot of attention. And most of your property policies and your clients' property policies, when they have business interruption coverage, will also come with the civil authority coverage. Now, what does that cover? Well, it covers lost business income and extra expense caused by action of civil authority that prohibits access to the described premises. The civil authority action must be due to direct physical loss of or damage to property at locations other than the described premises. So even though your office or your client's office didn't itself suffer physical damage, if the building across the street or across town did because of coronavirus, and you can point to the basis of the safer at home order as being that, at least in part, that physical damage at other locations, which cause you to have to shut down your business, then civil authority coverage may provide you with some coverage. The safer at home order is going to be included in your materials. It doesn't reference anything about physical property damage, but interestingly, I found an order out of Marin County, which we'll get to in a second, which does. The stay-at-home order enacted by Napa County specifically states that it's based in part on evidence of increasing occurrence of COVID-19 and the physical damage to property caused by the virus. So there you have a forward-thinking public official who is potentially going to help support claims and civil authority claims by constituents. And that's exactly what's happened with the complaint that's on your screen now. There's been a few cases filed now. This is one of the first by French Laundry, a great restaurant up in Napa County. And in that case, they are specifically seeking a declaratory relief that the Napa County order constitutes a prohibition of access to the plaintiff's property, and that the order triggers coverage under the civil authority coverage. So I think this is where you're going to see a lot of interaction with the insurance companies and possible litigation. The next slide is a less common coverage and would probably be more important to clients than to law firms, but it's called dependent properties coverage. And what that says is that if your business suffers interruption and loss because of physical loss somewhere else in the world, within the supply chain, if you will, to your business, then that is also potentially a business interruption claim. And the next slide has a definition of what are dependent properties. And this is a particularly broad definition, so it includes properties that deliver materials or services to you. It includes properties that accept your products or services. So it could be things like if you are selling hats, it could be that if the manufacturer in China that manufactures your hats, if they've had their business interrupted because of a physical loss at their location by a covered cause of loss, and that impacts you, you have potential coverage for that. And similarly, if the malls at which you sell your product have been shut down because of direct physical loss by a covered cause of loss, you could potentially have some coverage. The last coverage before we get to the exclusions that I wanted to mention, you won't typically find in a property policy. This is something that is more often in the entertainment industry, but it's called imminent peril coverage. And what it says is if there's a covered cause of loss next door to you and you need to take some kind of action to mitigate against harm. So the prototypical example would probably be a fire. The building across the street is on fire and you need to move out your computer servers and so forth to avoid loss, then there will be coverage for that. But that raises some interesting questions. The grocery stores, for example, have cut back their hours because they need to spend more time disinfecting. If they have imminent peril coverage, would that lost business during that time potentially be something that's covered? Or would the extra labor expenses or product expenses that they're incurring to avoid imminent harm by disinfecting, are those things that are potentially covered? Those are all questions that should be asked. Now let's go to the bad news, which is the exclusions, because none of this really matters if you have some exclusions in your policy. And a number of years ago, the insurance industry did come out with a standard virus bacteria exclusion. And as much as I love as a policyholder's lawyer to try to find ways to get coverage, if you have this or your client has this exclusion in their policy, I think it's going to be hard for them to argue that there is in fact coverage under that policy. But the good news is that notwithstanding the fact that there's this standard endorsement, which I'm sure will become even more standard going forward, not all the policies that are out there have this exclusion. So what other exclusions might apply? What other things will the insurance company throw at us? Well, the next slide is the pollution exclusion, and I've seen rumblings that insurance companies may try to invoke this. It does have a very broad definition of pollutants, which include vapors and fumes and things like that. I don't think that you present a bar to a claim based on coronavirus. Even if you think that vapors or fumes include viruses, which I'm not sure that they do, I think you would get into some potential ambiguities. And as most of you probably know, if there are ambiguities, those get construed against the insurance company. And I think the reasonable expectation of the insured for a pollution exclusion is that they're talking about environmental contaminants, industrial waste, and so forth, probably not viruses. The next slide is another common exclusion, which is for mold. And this one, I think, comes arguably a little closer to the mark if you're the insurance company, because typically the exclusions are not just limited to fungus or spores, but sometimes broadly other microorganisms. And so then the question becomes, well, is a virus a microorganism? Is a virus alive? Now, I would say again that the reasonable expectation of the insured is that this exclusion is looking at things that are in the mold, fungus arena, not the virus arena. But if in order to answer the question as to whether a microorganism is alive, you have to consider, some fairly philosophical questions, like they did in this episode of Star Trek: The Next Generation, a great episode, in which the question was, is Data, the android, alive? And they got into some pretty deep things. Well, as some of you may know, whether a virus is alive is a real subject of debate in the scientific community. Viruses have no metabolic processes of their own. They can only reproduce by invading the cells of other organisms. They don't have cells of their own. They're just packets of DNA wrapped in proteins. So, we'll see whether the courts get into some of these metaphysical questions in interpreting whether a microorganism is alive or not. The next slide, I just want to keep you to keep in mind that even if you have a mold or microbe exclusion in your policy, that may not be the end of the story, because a number of policies have a more limited coverage for mold and microbe types of damages, which in this example, if you look at paragraph 6, there's a limited coverage for lost business income and extra expense that occurs as a result of mold or microbes. So don't be completely discouraged, even if there's a finding that microorganisms include viruses and that viruses are alive. The next page of this same endorsement has a definition of microbes, which is pretty specific as to what is and what is not a microbe. So let me just, in the 2 or 3 minutes we have left, say a couple words about third-party coverages. Most businesses, if they get sued, are going to look to their commercial general liability policies for potential defense and indemnification. An example of this could be a business sued by a customer for having caught COVID-19 at the place of business. Could think of some causation problems there, but certainly I could see some claims being made. I actually saw come over my email today information about a wrongful death case filed by a Walmart employee against Walmart, claiming that the Walmart had poor sanitary practices, and that's why the person caught the disease. It was not a California case, and I'm not sure why it's not a workers' compensation case. But you can see that, these kinds of cases can come. We certainly can envision nursing home residents suing die as a result of COVID-19 at a nursing home. So the next slide shows the basic elements of coverage under a CGL policy. There has to be an occurrence, meaning there has to be some form of negligence typically that causes bodily injury. I don't think that there'll be any dispute as to whether if someone catches the coronavirus, they will have suffered bodily injury. That typically includes a disease. So again, I think here the fight will come in the exclusions. There are, similar to the virus exclusion, some policies come with a communicable disease exclusion. That's another one where if your policy has that, I think it's going to be a challenge to get insurance coverage. And then again, CGL policies typically will include a pollution exclusion and a mold microbe exclusion. And for the same reasons that we talked about before, I think as a policyholder would have a pretty good argument that they'd at least be entitled to a defense of a case, even in the face of those exclusions. So I think that's most of what I wanted to say, Mike, unless there were any questions that I wasn't able to look at while I was talking.
Well, Steve, I'm interested in a question about the interplay of the virus exclusion on civil authority coverage. If you have a civil authority coverage, would the virus exclusion sort of trump that, as it were?
Yeah, I think that it would, because it's broadly worded. It says, will not pay for any loss or damage caused by or resulting from any virus. And remember, in order for the civil authority coverage to apply, you still have to have a covered cause of loss. And the exclusion, I think, broadly applies to all the coverages. I don't think it was, you have to take a look at your specific exclusion, because it's possible that it's keyed into maybe just one coverage and not another coverage. But I think most of the time it's going to be keyed into all the coverages. Sure.
I wanted to say, since we are running out of time, we've got a lot of questions. A number of people have asked whether we might answer the questions in writing or provide some sort of information. Both of you have provided resources in your presentation for people to get additional information. Especially Daphne, she has that whole page of resources, and I would encourage our folks to look at those resources to answer their questions. As Steve knows, the insurance questions often are very, very fact specific, and they turn on the language of your particular policy, and not all policies say the same thing. Even ISO policies. So I want to thank everybody for attending, and thank Steve and Daphne for giving us the benefit of your expertise.
Mike, can I just say one thing before you sign off?
You bet.
Yeah, on that topic. When in doubt, tender, because if you don't tender, you won't get any coverage. And if you will get our information, which has our name and firm. It doesn't have our email address, but we're on Google and we're on the internet. So if anyone wants to reach out to me with a specific question, I'd be happy to take a run at talking to them or answering a generic question.
All right. Very, very, very well put. Okay. Thanks again. These materials will be posted online on Facebook Live, our website, and on our YouTube channel. You will be receiving your certificate of attendance. And thanks again. Stay safe, be healthy. And we have another program coming up next Tuesday, and another program coming up the following Tuesday, addressing issues in real estate and taxation, litigation, and legal technology for the next couple of weeks. So thanks again, everybody. We'll see you soon. Bye-bye.